Hi friends! I hope you are having a fantastic day today. Welcome to LAWLOOKS, where I smoosh together law and makeup to talk about some of the more interesting or fun cases I learned about in law school. Quick disclaimer, nothing I say can or should be construed as legal advice. I cannot give you legal advice. If you do need legal advice, please obtain your own attorney and consult them on any particular matter. Okay, with that out of the way, I have cut my hair. It's much shorter now. Still, the purple's still there though, so I'm happy about that. It's a little rough looking right now, but that's okay. I have some fun little cat ears or zebra ears. So, in the spirit of Halloween, ooh, I actually kind of like this. Maybe I'll keep the cat ears, make it a thing. Let me roll up my sleeves a little bit. Judge Amy Coney Barrett was confirmed earlier this week, and I thought this might be a good time for me to reflect on the legacy of Justice Ginsburg and who she was as a lawyer before she got to the Supreme Court. Other than the legal disclaimer I do at the beginning of these videos, it's pretty clear that when I talk or analyze about things, this is all my opinion, and you're more than welcome to disagree. In terms of Justice Ginsburg, I do think that she was a fantastic legal mind. Her strategy was phenomenal. I mean, she could always see the big picture, and I think that's really important to realize right now in the state of our world today. And in general, I think a lot of times we lose sight of what's important in the long run. I think I'm gonna need a little bit more foundation. Actually, maybe I'll just use concealer. I've been going like less heavy on foundation lately. I don't know, that might just be like the trend that's happening, but anyway, if you've seen the recent movies and documentary that has come out about Justice Ginsburg, you'll likely already know the case that I'm going to talk about, Craig v. Boren, but hopefully I'll give you a succinct makeup-filled version of it. So our story starts in Oklahoma with a liquor law. So an Oklahoma statute basically said beer with an alcohol content of 3.2%, which is about half the level found in ordinary beer, could be purchased by women at the age of 18. But men would have to wait until they were 21. For any harder liquors, both genders would have to wait until the age of 21. The reasoning behind this law was basically that women mature earlier, and so they would be more responsible with beer. I'm not positive, but I think there was also an aspect of drinking and driving. So usually men were more likely to be drivers than women and were more likely to drink and drive. So the idea was to keep young, drunk men off the road. Either way you look at it, very paternalistic, right? One, saying that women mature earlier, or two, saying that men are not responsible enough. So basically, what would happen is that men under the age of 21 would just get their girlfriends to go buy them beer. But one guy, Mark Walker of Oklahoma State University, he was a 20-year-old freshman, decided to challenge this beer law in federal court because he was like, I want to get beer for myself. You're discriminating against me because of my gender. Now, the law explicitly punished beer vendors. It's kind of like if you're under the age of 21 and you try and buy beer or liquor at a liquor store, you won't get in trouble, but the liquor store will get in trouble. So Mark Walker's lawyer told Mark Walker to join a beer vendor, someone who sold the beer rather than someone who purchased it, because there was this worry that Mark Walker wouldn't have standing, i.e. he wasn't the person who was injured by the law. It would be the vendor. So Walker found a licensed beer vendor by the name of Caroline Whitener, who shared his views on the unfairness of the state law. And while the case was pending, Walker turned 21, so his case was basically moot. So a third co-plaintiff was brought in, Curtis Craig. That's where we get the Craig from Craig v. Boren. He's an 18-year-old male, and so there probably won't be any of this mootness or standing issues anymore. So that's essentially our setup of the case. Now, before I go into a full analysis of Craig v. Boren itself, I'm going to quickly go over the tiers of scrutiny. This is my Urban Decay primer potion. It stopped coming out of the tube, but there was so much left in it. I always cut open all of my products because there's generally a whole bunch left. Okay, the tiers of scrutiny are tests used in judicial review, generally for equal protection or substantive due process claims. So, for example, for age discrimination, race discrimination, and gender discrimination. And they range from, there are 3 scrutinies, and they range from least rigorous to most rigorous. On one end of the spectrum, the least rigorous, we have the rational basis. The burden is on the plaintiff to show that the government has no rational basis for this law, i.e. that the law is not rationally related to a legitimate government interest. The burden is on the plaintiff here, who is claiming the discrimination. Age discrimination falls under this standard of review. It's very, very easy for the government to pass this standard of review. So generally, if you fall under rational basis, the plaintiff is likely going to lose. On the other end of the spectrum, we have strict scrutiny, which is the most rigorous test. Race discrimination falls under strict scrutiny. The law has to be necessary to fulfill a compelling government interest. It has to be narrowly tailored to achieve the compelling purpose, and it has to use the least restrictive means. Now, within rational basis and strict scrutiny, there's sometimes the courts take a little liberties, or different rights will have a different combination of those things, but that's the overall general basis. In the middle, not quite as easy as rational basis, not quite as hard as strict scrutiny. If the law falls under strict scrutiny, the government is probably going to lose because strict scrutiny is really, really hard to overcome. In the middle, we have intermediate scrutiny, and gender discrimination falls into that. And that's what we're going to be discussing today with Craig v. Boren. Craig v. Boren is kind of bumbling along in the court. It finally reaches trial in 1974 with Mark Walker's lawyer, Gilbert. And Gilbert has an interesting writing style. He uses a lot of exclamation marks and italics. His reasoning's a little muddled. At the time as well, the courts are a little unclear because the Supreme Court hasn't really stated whether gender discrimination falls under rational basis or is it strict scrutiny. What's going on? What are we doing? And then once it finally gets to a 3-judge panel, they favor unanimously for the state, and the state offered the drunk driving justification that men at 18 are more likely to be driving than women at 18, and they're just trying to protect the public. And the 3-judge panel also used the rational basis approach. Now, at this point, Attorney Ginsburg was already in communication with Gilbert. She already had this case on her radar. She was at the ACLU, at the Women's Rights Project, and she was like, listen, I can step in to help. Let me help you out a little bit here. And in 1976, the Supreme Court was like, we're gonna hear this case. And Attorney Ginsburg was like, all right, I'm gonna help you out. Let's see what we can do with this. So Justice Ginsburg wrote a brief, an amicus, a friend of the court, and she actually didn't even really address the scrutiny issue. She didn't say you should use rational basis or strict scrutiny or whatever. She latched on to the argument that these stereotypical characterizations of men and women are super outdated. Why are we doing this? She didn't really discuss rational basis or strict scrutiny. She was like, there's something in between. And at this point, legal discourse had already kind of said the court has been using some in-between standard of scrutiny for gender discrimination cases. So it makes sense to just use something in between. The Gilbert-Mark Walker team also ran into another issue. Craig had turned 21 10 days before oral argument. So his case was also moot. He was already 21. And they were unsure whether this case could simply stand on Caroline Whitener, the beer vendor. Of course, we all know how this case ends up. Justice Blackmun finds for Craig and Caroline Whitener. Intermediate scrutiny is introduced. It's a new tier of scrutiny that will be used for gender discrimination cases. It's what we follow now. All law students learn the 3 tiers of scrutiny, and none of it would have been possible without Attorney Ginsburg and her work at the ACLU, because this was not her only case in this realm. Frontiero, I think that's how you say it. Yeah, Frontiero v. Richardson came before this case. Also Reed v. Reed. Justice Ginsburg had a hand in Frontiero. In another case, Weinberger. And what's interesting about a lot of these cases is that Justice Ginsburg argued for equal treatment of men. She said, this is a court of 9 justices who are all men. How do I get them to care about gender discrimination? Well, I'm going to show them that men are discriminated against, and while that's a small incremental change and possibly a detriment for women in that one single case, overall, it's a win against gender discrimination. And I think that was Attorney Ginsburg's most compelling asset, that she saw the strategy. She played the long game. When Justice Ginsburg passed, my constitutional law professor wrote in Politico, she was a lawyer's lawyer. She was cautious by temperament, a master proceduralist, a strategic thinker who always played the long game. She developed a reputation for feistiness, but her secret weapon was that she was in no hurry, which I think is a very accurate statement based on what I've heard about her, but also one that I think I can take away as a new law graduate, someone who is going into the profession. I think probably during one of my moot court classes, someone mentioned to me that when Attorney Ginsburg was asked a question by the court, sometimes she would wait so long to answer that the judges or justices would ask her again or ask her if she heard them because she just didn't say anything. And she was like, yeah, no, I heard you. I'm just thinking about my answer. As new attorneys, like, we're so scared when we get up there, and if a judge asks a question, it's like, oh my god, you have to answer now. But Justice Ginsburg knew that she could take her time, and she wanted to wait to give a thoughtful answer. And I think about that a lot, because sometimes, yes, we do have to be quick and think on our feet super fast. But overall, I think it's better to just pause, wait, play the long game, think about what you're gonna say, play the full strategy out to the end, see the big picture. And I think that's the biggest takeaway that I personally can take and use from what Justice Ginsburg gave us here, and of course all of the doors that she opened for women. I will be eternally grateful for her work and the work of dozens of other women and men and individuals who opened the doors for me to be where I am today. At the same time, I can acknowledge that Justice Ginsburg was not a perfect person. She had her own flaws. She grew up with a certain amount of privilege. She only had 2 black clerks her entire judicial career. Some of her jurisprudence on Native American land is not what we would expect from a liberal justice. I acknowledge these things. I know that they can be hard to reconcile, but at the same time, I do think we can celebrate what she did do while calling out the things that hurt and hope to strive for better in the future. I'm not sure if that will happen with the confirmation of Judge Amy Coney Barrett, but I'm not here to opine on that. As for what happened to the parties in the case, Caroline Whitener still talks about it, I believe, along with Curtis Craig. I know in 2016 they did Constitution Day and they discussed it, at Oklahoma State University. I believe there is a More Perfect podcast episode about this as well. Oh my goodness, I just realized I didn't even discuss the opinion in depth. Okay, so Justice Blackmun delivered the opinion of the court. There was a dissenting opinion, and Justice Blackmun, was it Justice Blackmun? Who delivered the opinion of the court? Not Justice Blackmun. Justice Blackmun wrote a concurrence. Justice Brennan delivered the opinion of the court. Like I said, he brought about a new tier of scrutiny, intermediate scrutiny, and also expanded third-party standing, and basically said that because Caroline Whitener, the beer vendor, would be economically affected, there would be a nexus to the injury itself, and therefore the constitutional violation of the gender discrimination. So that was a new test for standing. As for the issue that Craig turned 21, 10 days before the oral argument, they were like, that's fine. The third party, Caroline Whitener, the beer vendor, can stand in his place. So there was no issue there either. As for the dissent, it was Justice Berger and Chief Justice Berger and Justice Rehnquist. Rehnquist basically said that this falls under a rational basis. We don't need another tier of scrutiny. Why are we doing this? We're just making the law more complicated. Please stop. Chief Justice Berger basically agreed with that, but also said that this expansion of third-party rights is a no-go. A litigant should only assert his own constitutional rights or immunities. The economic injury part of the third-party standing was too much for him. He was like, nah, I'm not gonna do this. I forgot a lipstick. I'm back with a lipstick. We're going a little dark. But without this case, we probably would have stayed in rational basis land with gender discrimination, which, like I mentioned before, usually the plaintiff doesn't win, the government wins there. So it would be much harder to win those gender discrimination cases, whether you're arguing on behalf of men or women. But I'm just always in awe of what Attorney Ginsburg accomplished, her ability to play this long strategic game and make it work. And that's truly what the legacy of Justice Ginsburg means to me. And that's my takeaway from what she gave to the law. And that, my friends, is Craig v. Boren. Thank you so very much for watching me and listening to me talk about what Justice Ginsburg's legacy means to me personally. If you like this video, please give it a thumbs up and or subscribe if you feel so inclined, but absolutely no pressure. Just thank you so much for watching and being here and making it to the end of this video. If you have thoughts, comments, let me know what Justice Ginsburg means to you, what her legacy means to you. Oh, also, the company Held, if you use the code LAWLOOKS, you can get $2 off of products on that site. I don't earn anything from it. You guys just get a discount. So if you enjoy anything from there, definitely check it out. I got a t-shirt. I got the Leonard v. PepsiCo t-shirt and a Roe v. Wade sticker in hot pink that I will put on my computer as soon as it gets here. And one last thing, I also did a podcast with my good friend Mudit Verma. I will drop the link below for that video. You can check it out on YouTube and check out his channel. He's a very funny guy doing some stand-up comedy in these odd times, so definitely give him a look. And I think that is all I have. Thank you again so much for watching. I really, really appreciate it, and I will see you all next time. Bye!